Hello, everybody. I think we're live now. Welcome to the 2023 Hot Topics in Environmental Law Summer Lecture Series. This is our first lecture of the whole series, so we're excited. I'm sure there are a lot of familiar faces joining us here, and we're excited to have you back. I'm Jenny Rushlow. I'm Dean of Vermont School for the Environment and Faculty Director of the Environmental Law Center, as well as a professor here at Vermont Law and Graduate School. As a reminder, each of these talks is worth 1 CLE credit in Vermont, and you're required to keep track of the talks that you attend for your CLE reporting records. We will have time for Q&A after the presentation today, so if you're watching on the VLGS YouTube or Facebook pages, you can enter questions in the chat on those sites or in the comment space, and we'll get to as many as we can. So I'd like to now introduce today's speaker. Today, we are very pleased to welcome Professor Cale Jaffe. Professor Jaffe is the director of the Environmental Law and Community Engagement Clinic and a professor of law at the University of Virginia School of Law. Through his work with the clinic, he's represented a diverse array of public interest clients, from a community group working to preserve an early 20th century Black schoolhouse in Cumberland County, Virginia, to local governments filing amicus briefs in the Supreme Court of the United States. Before joining the faculty at UVA, Professor Jaffe was an attorney with the Southern Environmental Law Center and the director of the center's Virginia office for 3 years. In 2014, he was appointed to serve on the Governor's Climate Change and Resiliency Update Commission in Virginia. And in 2020, he was appointed to serve on the Virginia Coal and Energy Commission. He holds a BA from Yale University and earned his JD and master's in legal history from the University of Virginia. And after he graduated, he held clerkships with the U.S. District Court for the Western District of Virginia, as well as the U.S. Court of Appeals for the Fourth Circuit. This summer, Professor Jaffe is at VLGS as our 2023 Distinguished Climate Law Scholar. And today he'll present a talk titled STATUTES v. EPA, the Supreme Court's bombshell ruling and what it means for wetlands, wildlife, and the climate crisis. Please join me in welcoming Cale Jaffe.
Thank you, Jenny. I'm really excited to be here. Let me say at the start that I had initially planned to talk today on what I am calling or what I would call the climate whispers. And I'll tell you more about what that means in a minute here. But then we got this bombshell of a legal development just last week, a week ago today, from the United States Supreme Court in Sackett v. EPA, this major Clean Water Act case. And I just felt that we had to address that. And I actually think it connects to climate whispers, so we'll get to that in a second. But as you might have heard, it's a pretty remarkable decision in terms of rollback of Clean Water Act protections for adjacent wetlands. I also think it's a pretty remarkable decision in its assertion of power by the Supreme Court over Congress and the language that Congress put into the Clean Water Act, and over the executive, the 8 U.S. presidents, in fact, who had interpreted the statutory language in various regulations. So I've got a bit of a slideshow here. I'm gonna see if I can get that rolling and share my screen, as we've now learned to do. So let me see if this works. All right. Make sure I'm sharing the right document, and let's see if we can start the slideshow. From the beginning, a very good place to start, as Julie Andrews once told us. And I got to swap the display settings. Let me swap. There we go. All right. Here we go. So hopefully you all can see the slides here as we go. So, with students in the environmental law clinic, I at UVA, we authored an amicus brief in the Sackett case. We represented the Idaho Conservation League. And so it's a case that I've been following very closely for quite some time now. And when the breadth of this decision became clear, I knew that we really had to address it here in this hot topic series. I mean, what is a hotter topic than this bombshell Supreme Court decision? Maybe the debt ceiling deal that the House just voted on last night, that includes a green light for the Mountain Valley Pipeline in Appalachia. That also is a pretty hot topic and exciting here. I'll try to address both of them before our time is up. And I'm going to get to all of those hot topics in just a bit. But I still want to begin by talking a little bit about this idea of climate whisperers as a term that I'm playing around with. So here's my plan, and hopefully y'all will be cool with this. I'm going to start off by explaining what I mean about climate whisperers, the original talk that I planned for today. But then I'm going to pivot quickly to talking about Sackett versus EPA. We'll get to do a deep dive on that case. And then we'll come back to the climate whisperers idea. And what I'm hoping is that I'll be able to sort of share my view that this mindset of a climate whisperer might be able to help environmental advocates and conservationists and really all of us who are now sort of searching for a way forward post Sackett v. EPA. All right, so first, what is a climate whisperer? All right, simply put, I think a climate whisperer is someone, an environmental advocate who has succeeded in working on climate change policy in sort of politically conservative or divisive environments where there's sort of hostile environments where we might not think progressive climate policies could take root. And yet these sort of climate whisperers are seeming to succeed in this very difficult soil. So, if we think about advocacy on climate law and policy, it's really no secret that the issue has become intensely politically polarized. And it's really hard to build a broad-based coalition to work on climate policy if a sizable portion of the population thinks that the issue is a hoax, or as you can see here, a former US president who put it in a tweet a few years ago, that this is just some concept made up by the Chinese in order to make US manufacturing non-competitive. It's hard to find common ground, and we can't even agree on what day it is. So back in 2018, I wrote this paper in the Georgetown Environmental Law Review on melting the polarization around climate change politics. And my idea then was to see, is there some way we can sort of find common cause with others who might have been dislocated by this Trump moment in 2018. I was thinking, never Trumpers, maybe conservative defense hawks, who might recognize climate as a national security risk. Is there a way to sort of build a broader coalition on climate policy here? But what I'm sad to report is that since I wrote that paper in 2018, the polarization on climate policy has actually just gotten worse. Gallup had a poll out recently asking folks whether they thought the global warming threat was quote unquote exaggerated. And the number of respondents saying, yes, it's exaggerated has actually grown from 2018 to 2023. So it was about 33% said it was exaggerated back when I wrote that paper. Today, it's almost 40%. Gallup had another report out just in April where they reported that the gap between parties on environmental protection has never been larger than it is today. So, to the idea that there might be some ability to melt the polarization on climate politics by building these bridges, maybe I was a little misguided, maybe I was Pollyannish about it. We've got this difficult trend of increasing polarization. And yet there is some contrary anecdotal evidence that's flowing the other ways that I find really intriguing. So let me tell you just one example of it. So Batesville, Arkansas is a rural community of about 10,000 people in Independence County, Arkansas. It's a strongly Republican county. In the 2020 presidential election, Independence County went 77.5% for Donald Trump. Joe Biden barely captured 19% of the vote in 2020 in Independence County, Arkansas. And yet the school district there in Batesville worked with this company called Integrity, based out of Little Rock, a solar and energy efficiency group, to install this. And you can see the picture here, this 759 kilowatt solar system on the high school and on the junior high. They made investments in energy efficiency in the schools. You know, again, this is a place that voted 4-1 for Donald Trump over Joe Biden, and yet also supported a $5.4 million bond to purchase a solar energy system and make these energy efficiency upgrades. And the story, you know, was highlighted in the New York Times, did a piece on it. CBS National News, as you can see here, did a story on it. They called it From Sun's Rays into Paydays, because the money that the school district ended up saving from the solar investment ended up funding increases in teacher salaries. The story was highlighted to me, I should say. I should make sure to give a shout out to a group called Generation 180, based in Charlottesville. I'm on the advisory board there, and they've been working on this issue and highlighting this story. But one of the teachers at the Batesville High School who's quoted in this CBS story, Jeannie Repke, she advised, she says, "Don't sleep on Arkansas. We'll surprise you every time." And indeed, they did surprise me. This is exciting. Political polarization on climates, it's a worsening problem. And yet the folks at Entergy working on solar and energy efficiency, they really chose to sail right into the storm here. They went right to one of the most conservative counties, a place where, Joe Biden's only getting 19% of the vote. And so how do they do it? These folks, the folks at a group like Entergy, those are the people I'm calling climate whisperers, because they're finding a way to talk to the school district, to listen to the school district in these communities that might be hostile to climate policy, and in fact, convincing the school district to adopt a climate policy that is more progressive than you might see in some school districts in New York or Massachusetts or California. And so I want to know, how do they do this? How do they steer into this storm and succeed? That's sort of the climate whisperer story that I want to understand. But I'm going to ask you all to dog-ear that page right now, hold that, and we'll come back to climate whispers. But now I'm going to move into the bad news part of the story and start off with Sackett v. EPA. Okay, so what's going on with the Sackett case? So let me just pull back a little bit on the basics of the Clean Water Act, if you're not familiar with it. So the Clean Water Act protects, quote unquote, navigable waters, which are defined expansively as the waters of the United States, including the territorial seas. And you've got a black and white picture here of Sackett of Priest Lake on the side of your screen here, from the Priest Lake Museum in Idaho, where the case sort of originated out of. Obviously, clearly a navigable water, although Justice Thomas, joined by Justice Gorsuch, cast some doubt on even whether this lake might be protected, but save that for another day. Anyway, so we've got Priest Lake here as a navigable water, and then following amendments to the Clean Water Act in 1977, the act also, Congress explicitly protected wetlands adjacent thereto, at least in some circumstances. So adjacent wetlands and these waters of the as part of these waters of the United States. And so one question before the Supreme Court in Sackett was whether the term, what the term adjacent meant. Were wetlands adjacent only if they were physically touching a navigable water, or were neighboring wetlands that had a significant hydrological connection to a navigable water also considered adjacent? And I've got here, I said we did a brief with students in the Environmental Law Clinic at UVA, where we represented the Idaho Conservation League. This is an image from our brief where we sort of highlighted using Google Earth the connection between the wetlands and Priest Lake. You can see there's this broader wetlands complex called the Kalispell Bay Fen. It used to flow all the way to Priest Lake, which is right there at the bottom of the image. You can see some houses before the Clean Water Act was enacted were developed sort of right along the edge of the water. And then the Sackett wetlands were sort of in between the remaining Kalispell Bay Fen, these houses in the lake, about 300 linear feet from Priest Lake to the Sackett property. And the connection between, if we're trying to determine if the Sackett property is adjacent to the Priest Lake, frankly, I would have thought this would be an easy case. There's a lot of connection here. It's very hard to see in the image, but there's a small blue line that shows a channelized creek. It used to flow straight through to the lake. It's now been channelized around the development. But the EPA documented trout swimming up that channelized creek to this sort of broader Kalispell Bay Fen and spawning above the Sackett property. We had just the sheer luck. We found this University of Idaho a report, master's thesis that was done by a grad student back in the 90s, where he happened to decide to study the rate of groundwater flow from the Kalispell Bay Fen into Priest Lake right at this spot. And he documented in that report just this steady, sustained flow of groundwater directly from the property right into Priest Lake. So the impact on water quality for the property is pretty obvious. You've got this channelized creek, you've got the trout, you've got the hydrological flows directly from this Kalispell Bay Fen. It should have been an easy case. And to think about how easy it should have been, imagine the Sacketts now go forward and build a house on these wetlands in this spot. If they've got friends coming out to visit them, you can imagine they might say, yeah, you just come down the road, our house is adjacent to the lake. That would be a totally apt description of the property, adjacent to the lake, adjacent wetlands. And yet the Supreme Court said that these wetlands, in really a bombshell decision, were not adjacent. And to make that finding, first they had to adopt a view that the Supreme Court itself had rejected, or at least a majority of the court had rejected back in 2006 in the Rapanos case. And the ruling now going forward after Sackett is that wetlands are adjacent only if they have a continuous surface water flow, surface water connection to a navigable river waterway, such that the wetlands are, quote unquote, indistinguishable from the navigable waters. So you can imagine, the houses right along the shoreline there, maybe those were built again before the Clean Water Act was enacted, but you can imagine that those houses might have had some jurisdictional wetlands. But the Sackett wetlands now, the Supreme Court, despite the fish, despite the trout, despite the channelized creek, despite this clear flow of water from the property to the lake, are no longer considered adjacent. It's not how, as I've said before, a common sense understanding of what adjacent means. It's also shocking to me because the Trump administration, in its ruling, the Army Corps of Engineers recognized that adjacent includes wetlands that might be separated from a navigable water by a berm or a dike or some other barrier. But nonetheless, if those wetlands had this sort of strong impact on water quality, they might be adjacent. So that's the Trump EPA would have had a broader view of adjacent wetlands than what we're seeing from the Supreme Court in Sackett. And Congress, of course, in its language in Section 1 of the Clean Water Act, Section 101 of the Clean Water Act, spelling out that the objective of the act is to protect the chemical, physical, and biological integrity of the nation's waters. There's really no discussion in the majority opinion in Sackett about Congress's language here on the purpose of the act. Congress explicitly saying we're going to protect wetlands adjacent thereto, spelling out this broad purpose. You've got 45 years at least, as Justice Kavanaugh noted in his concurring opinion, 45 years of 8 straight presidential administrations, beginning in the 70s with Carter, going through Reagan, George H.W. Bush, the Clinton years, George W. Bush, Obama, Trump, as I mentioned, Biden most recently, all these presidents had varying definitions of the jurisdictional reach of the Clean Water Act, but they all agreed at least some wetlands that don't physically touch inhaled water would still qualify as adjacent under the language that Congress has provided. And, I just have to pause here because it is truly astounding to me that a majority opinion from the Supreme Court, would not give at least some deference to these co-equal branches of government, to what Congress has said, to what 8 U.S. presidents have said. You would think that the court would have at least upheld the narrowest definition of adjacent wetlands that these other co-equal branches of governments had never even disputed in 45 years of Clean Water Act enforcement. So I'm really shocked we didn't see at least that level of deference to the other branches. Now, that's a lot of talk about SACIT, and it may feel pretty depressing, and maybe at this point you're saying, can we please pivot back to talking about the climate whispers? That sounded more hopeful. And trust me, I want to get back to a more hopeful note. I hope we will end on a hopeful note, but to get there, I've got bad news. Unfortunately, things have to get a little bit worse, because the Clean Water Act does a lot more than remedy water pollution. A Section 404 permit under the Clean Water Act, if adjacent wetlands trigger this sort of review under the Clean Water Act, it can also trigger reviews by congressional design under other federal statutes. So the National Environmental Policy Act, enacted just a few years before the Clean Water Act in 1969, triggers environmental assessment, sometimes environmental impact statement, if you have a major federal action that's significantly affecting the quality of the human environment, as the language here from the Act says. So the need to sort of issue that permit under the Clean Water Act, that can be a triggering event for the National Environmental Policy Act. And then you get this sort of holistic review where NHPA, the National Environmental Policy Act, is asking agencies to look to make sure to protect all sorts of sort of interlocking, holistic impacts. So look at aesthetic impacts, historic impacts, cultural resources, health impacts, cumulative impacts, sort of the interlocking ecological effect of how the statutes work. I mean, the original idea behind NHPA was that agencies had been running, federal agencies had been running to sort of approve and permit projects without really considering the full panoply of environmental harms that those projects might cause. And NHPA just says, hey, let's try to step back, take that 30,000-foot view, give that holistic view of what's going on here. And maybe if there's a really bad project, we can either nip it in the bud, or we can look at an alternative that has less of an impact. So, but again, you don't get that NHPA review. You don't get that holistic review under the National Environmental Policy Act if the initial wetlands are not jurisdictional under the Clean Water Act. And it's not just NHPA. Under the Endangered Species Act, federal agencies have to consult with the Fish and Wildlife Service if any action that they are authorizing or funding or carrying out might jeopardize the continued existence of an endangered or threatened species. Again, if the wetlands aren't jurisdictional, you might not get that Endangered Species Act consultation with Fish and Wildlife Service. Under the National Historic Preservation Act, again, if an agency is going to issue a license or expend federal funds, they've got to take into account the effect on historic properties. And if the wetlands being dredged, that sort of Section 404 permit, are no longer jurisdictional, the Corps isn't playing a role, then you might not look at those sort of broader impacts on historic resources. My main point here is that these holistic reviews, they are by congressional design. Congress is recognizing with these interconnected statutes that the natural world is interconnected. And so the statutes require this holistic review. And if you take out that first brick, you may not get the whole building. So SACIT is a major Clean Water Act case, but it has the potential to be far more than that because of these other reviews. Now, let me give you one example of what I mean about sort of how this sort of ripple effect might be short-circuited because of the Sackett opinion. I mentioned at the outset the debt ceiling deal. I haven't read any news this morning to see if there's newer developments, but one of the big stories that is percolating out so far is that President Biden and Kevin McCarthy have agreed on a deal that includes a green light for the Mountain Valley Pipeline, this 300-mile long methane gas pipeline that would run through Appalachia and West Virginia and Virginia. And environmentalists are naturally upset about that. But what's I think noteworthy here is that there are hundreds of streams and wetlands along the path of the Mountain Valley Pipeline, or the proposed Mountain Valley Pipeline. A lot of wetlands here. And normally, jurisdictional determination, if those wetlands were adjacent to a nav of water, they are protected under the Clean Water Act, then that would trigger these holistic reviews I was just mentioning. But if following Sackett, a lot of these wetlands are no longer jurisdictional, or some of these wetlands are no longer jurisdictional, then we don't get those holistic reviews. And so maybe what was happening here is that the Biden administration team sort of looked at what had just happened in the Sackett decision last week and thought, this, we may not be conceding all that much to concede the Mountain Valley Pipeline, because so many of the federal reviews have been short-circuited for projects like this, and for this particular project potentially. So in light of that, they might have concluded that it was an easier concession to make, because it was one that the Sackett decision had already lost for them, at least in part. All right. As I said, we've gotten even more down into the bad news, the depressing news from an environmental standpoint. Maybe you're really depressed at this point. I apologize for that. You might now be asking, please, let's talk about those solar guys in Arkansas. That sounded hopeful. So can we get back to them? And yes, now we can. Now that we understand sort of the full panoply of how things have gotten more polarized and harder for environmental advocates in the law, now let's see if we can chart a way out of that hole. And so let's go back to talking about climate whisperers in Arkansas, because I think the secret to their success, to Entergy's success in building this, was they did not come in back in Batesville, Arkansas and say, well, here's what you need to address climate change. Rather, they listened. They heard about a school district that said, well, we're spending $600,000 a year on utilities, on electric and heating and water, and we're struggling to pay teachers. We're losing a lot to early resignations. We've got some of the lowest teacher salaries in the state. And they heard all that and they said, well, we can help you address that. And that's where this sort of solar project was born. It wasn't necessarily a climate project. It was, helping the school district manage its own identified needs. And what's exciting is how it has built since that, how it has continued to build since that story. So the superintendent of schools in Batesville, Arkansas, is a guy named Michael Hester. He, after this success, he got so excited about it, he started working with the Audubon Society in Arkansas. And they worked to enact a Solar Access Act in Arkansas in 2019 that expands opportunities for solar net metering and third-party power purchase agreements for solar. In fact, Dr. Hester from Batesville was up at Harvard's Graduate School of Education just earlier this month in May, speaking as part of their Climate Action Week on a panel that was titled, How Leaders Can Empower Communities to Act for Climate Resilience. Michael Hester is the guy on the sort of the far right of my screen. I'm not sure if it's flipped for you all, but he's sort of there on the end. Anyway, so this is amazing, right? Somebody in Arkansas who was initially working on teacher salaries and high utility bills is now, up at Harvard talking about empowering communities to act for climate resilience. It started with listening. I really think that is the key success point for a climate whisperer. And I know that sort of sounds easy. Maybe it sounds, again, Pollyannish, but let me give you one example where we as the environmental community did not listen and didn't have so much success. So I don't know if y'all remember this. I remember this back in 2017. Al Gore, former vice president, had this town hall on CNN, first year of the Trump administration. It's moderated by Anderson Cooper. And, here you've got Al Gore, former vice president, Nobel Peace Prize winner for his work on climate change, an international figure. And he's being asked this question by this guy here you see on the screen, James ESKRIDGE. He was the mayor of the town of Tangier in Virginia. It's on this historic island, Tangier Island in the Chesapeake Bay. It's been home to a generation of crabbers and oystermen, and it's quickly disappearing due to sea level rise. This story, by the way, is told in this amazing book by Earl Swift that I highly recommend. I'm thinking of teaching it in the clinic this coming year. You can see it there. It's Chesapeake Requiem, a year with the watermen of vanishing Tangier Island. So Swift tells this whole story in that book. But he quotes ESKRIDGE asking Al Gore this question. And I'll just read the quote. ESKRIDGE says, I'm a commercial crabber, and I've been working with the Chesapeake Bay for 50 plus years. I have a crab house business out on the water, and the water level is the same as it was when the place was built in 1970. Our island is disappearing, but it's because of erosion, not sea level rise. Unless we get a seawall, we will lose our island. But I'm not seeing any signs of sea level rise. So that's the question that ESKRIDGE asked Al Gore. And Gore, and this was widely reported at the time, responded with a tone and a speaking style that was perceived, at least to those viewing it on TV, as condescending and dismissive of sort of the Tangier Island viewpoint. He talked about scientists and what they're documenting. He had a little joke in there that some folks perceived as making fun of ESKRIDGE. I don't think that was his intent, but that's how it was perceived by TV viewers. A lot of folks watching it on TV thought that sort of ESKRIDGE won this mini debate with Al Gore. And, how did that happen? And I don't want to beat up on Al Gore because obviously he's a Nobel Prize winner and, an illustrious leader in the climate movement. I remember reading his book, Earth in the Balance, many years ago when he was a U.S. senator. So immense amount of respect for Al Gore. But what is the moment that he missed right here? And if he had sort of sat to listen, he might have realized, oh, there's a lot here that ESKRIDGE and I agree on. We're concerned about the erosion. We're concerned about the loss of the island. He might have asked about what, why a seawall? And if he had started to ask questions on points of agreement, maybe they would have he would have learned a few more things. He might have learned that the folks on Tangier Island have been working with the U.S. Army Corps of Engineers literally for decades, trying to get them to build a seawall or take some sort of physical action to protect Tangier Island. Immensely frustrating. And, he continued to ask about it. ESKRIDGE might have told him about a place called Poplar Island in the Chesapeake Bay. That, like Tangier Island, is disappearing, it's eroding, but unlike Tangier, it has no people. It's an uninhabited island. Nevertheless, the U.S. Fish and Wildlife Service worked with the Army Corps of Engineers to take sort of dredged material from shipping lanes to rebuild Poplar Island because the Fish and Wildlife Service determined that it was important habitat for osprey, eagles, terns, and sort of other important shorebirds. And so Tangier Islanders were understandably frustrated about, why is it that our federal government is spending all this money to protect birds and wildlife and not doing anything to protect people and their livelihoods? If he had sat and listened and asked those kind of questions, I'm not saying he would have turned ESKRIDGE around on sea level rise in that moment, but he might have been perceived less as a climate know-it-all and more as a climate whisperer. And, who knows where that might have led. All right, so what does being a climate whisperer mean for us as lawyers? Well, in addition to running the environmental law clinic at UVA, I also teach a lecture class on professional responsibility. And it is surprising to me how little the American Bar Association's model rules of professional conduct really talk about listening to our clients. There's a lot on how to advise them, how to talk to them, but not a ton on how to listen to them. I'll give you a few examples. The comments to Rule 1.1, which is the baseline rule on competency, talks about, says competent handling includes inquiry into the client's problem. So inquiry, so presumably you're asking them questions. Okay, that's a little bit of listening. Then Rule 1.2, which talks about the scope of representation, says that lawyers have to abide by a client's decisions concerning objectives of representation. All right, so clients are making the decisions, and then we're carrying them out. That's Rule 1.2, and then I've got Rule 1.4 up here, which is the baseline rule on communication. And it's got this odd phrasing here. I don't know if you can see it. It's in Rule 1.4A2, where it says that lawyers have to reasonably consult with their clients about the means by which the objectives are to be accomplished. It's an odd phrasing, to me at least. What does this mean? Like, we have to reasonably consult with our clients. We have to talk to them a little bit, not too much, just a reasonable amount, and then we can get going on what we want to do to carry out their objectives. We'll consult with them a little bit, a reasonable amount. Let's not go overboard on it. There's nothing in here about just listening for listening's sake. There's nothing in the ABA rules about just sitting back and admonishing lawyers to understand a client's fears or concerns, their aspirations, their expectations for this strange process getting involved in the legal system. Listening to all that without trying to immediately translate it into action. That's sort of the key to listening, as I see it. I've got a picture here on the screen of Gerald Lopez. He's now emeritus professor at UCLA Law. Back in 1992, he wrote this powerful book called Rebellious Lawyering, where he talked about lawyers, being parts of coalitions with the communities they work with, and jettisoning this traditional model of representation, where you assume that your primary goal is just to address a narrow legal problem. And I think that really reflects part of the mindset that I think about that we need as climate whisperers. So at least within the legal community, what I think, it would be great if we had some amendments, some additional comments to Rule 1.4 here on how to listen for listening's sake, to get into that mindset. And let me be clear here. I don't think, I really don't want to be Pollyannish about this. The Sackett decision, as I said, is a bombshell, as I see it, in the worst sense. Again, it's shocking to me that the court rejected even the narrowest definition of wetlands adjacent, as outlined by Justice Kavanaugh in his opinion, that the other two co-equal branches of government had never even disputed. It's bad for what it means for the rollback of Clean Water Act protections, because of the way that the Clean Water Act is daisy-chained to these other statutes, the National Environmental Policy Act, Endangered Species Act, National Historic Preservation Act, sort of holistic environmental reviews that begin with issuance of a Clean Water Act permit for dredging and filling wetlands under Section 404. And I'll say it again, I think Sackett might remove so many wetlands from protection under federal law that it gave the Biden administration, they might have thought they weren't giving away all that much by including the Mountain Valley Pipeline in the debt ceiling bill. The Supreme Court in the Sackett decision had already given away a fair bit of that. So, how do we navigate our way out of that? I know it's not a panacea. I don't think the climate whisperers idea is a panacea to these problems. But I think over the long term, if we can adopt that approach of listening for listening's sake, we might find common cause with more Arkansas school districts looking to build solar, common cause with Chesapeake Bay watermen, common cause even with folks like Michael and Chantal Sackett in Idaho. I know it's not going to be a solution to all of the problems that the Sackett decision creates, but I know it's the place where I would like to start. And I will leave it there. Happy to take questions that we might have.
Perfect. Thank you, Cale. So at this point, we have a few questions, or sorry, a few minutes for you all to ask some questions. And so in order to do that, please enter your questions in the chat or the comment space wherever you're viewing, and we'll get through as many as we can. So to get started, Cale, what role do states play in the implementation of the Clean Water Act? And can you talk about whether states will have space to do better than what the Supreme Court is requiring or interpreting from the Clean Water Act at the federal level?
Yeah, that's a great observation, Jenny. So many states have done historically very little under the Clean Water Act because they've deferred so much to sort of the EPA rules. So in Virginia, for example, a Virginia water protection permit begins under a joint permit process where it's really just parroting what the federal protections are. And so absolutely, there may be wetlands that are clearly jurisdictional under state law that are no longer jurisdictional under federal law. And so these state agencies are going to have to pick up that ball. It may be in some states, new legislation is needed depending on how much the state legislature has tied state agencies to doing no more than what the federal government will provide. So there's undoubtedly going to be a bit of a hole at the beginning here when there are these gaps where neither the states or the feds are regulating, but absolutely there's a role here for the states to pick it up. And, we've seen that in other areas. Virginia on climate policy in 2020, the state enacted the Virginia Clean Economy Act that mandates the state's electricity sector get to zero carbon by 2050, 2045 for most of the states by one utility, and 2050 statewide. That's the kind of bill that, we just have not seen any appetite for at the federal level. And yet Virginia adopted it at the state level, and other states have adopted similar mandates. So absolutely, we may see a pivot back to more state-centric environmentalism. We may have to.
Yeah, and you talked about climate as kind of the lightning rod for political division, but the Clean Water Act and these jurisdictional issues have also been an incredible lightning rod and an area of political division, but perhaps with some different groups speaking up on either side of those issues. Like I think about the agriculture community and opposition to expansion of the Clean Water Act jurisdiction, right?
Yeah, absolutely. And, maybe there's some other signs. There's the National Pork Producers Council versus Ross case, the Supreme Court case about sort of California's humane slaughter rules that had been challenged, whether they should be preempted, and California was able to defend those rules. There was the Suncor Energy case out of Colorado where the Supreme Court, you don't want to read too much into a denial of cert, but denied cert on this challenge to Boulder County, Colorado's climate actions. So yeah, I had sort of penned out an essay for in 2020 on environmental federalism as form shopping, sort of trying to find the best place to work right now. Maybe we need to adopt that mindset on water protection. We've got a lot of work to do.
That's for sure. Okay, so when you were speaking about the Sackett decision, you mentioned Rapanos in passing. And so for those who aren't so familiar with Rapanos, could you say a little bit more about what was significant about that decision and to what extent Sackett modifies the status of case law for the Clean Water Act?
Yeah, so in 2006, Rapanos versus the United States is that was the bombshell clean water case at that time. And Justice Scalia penned this opinion that was a plurality opinion, did not get a majority of the votes, that adopted this test that's saying, you have to have a continuous surface water connection to a navigable river or waterway such that the wetlands are essentially indistinguishable from the navigable river. I think Justice Scalia was envisioning this idea that if I'm standing waist deep in the river, I know I'm in the river. If I start to walk out of the river, well, maybe the water's up to my knees. I'm still in the river. May I go a few more steps? I'm now in this squishy, marshy grass where my feet are still wet. And now it's hard to tell where the water ends and the land begins. And okay, EPA and Army Corps of Engineers, you can regulate that. It's a view that frankly ignores what wetland scientists and hydrologists have told us about how water and pollution flows to waterways. And it did not get a majority of the court in 2006. Instead, there was this solo opinion that was the narrowest way forward. So it became very influential by Justice Kennedy, where he talked about a significant nexus. And that phrase actually comes from an earlier case, a 2001 case, the Swank decision on clean water. And the idea there is that if wetlands have a significant nexus, a significant hydrological connection to a navigable water, such that destroying those wetlands is harming water quality in the river, then those wetlands should be protected under federal law. And that significant nexus test, which we've relied on for so many years now, was explicitly thrown out. Interesting enough, by all 9 justices in the court, rejected the significant nexus test as essentially unworkable.
You spoke about how in the Sackett decision, there's very little mind paid to the other 2 branches of government. Certainly, we saw that relative to the executive branch in the West Virginia VEPA case, and here it seems to go a little farther on the legislative branch side. Do you see any likelihood of modifications to major environmental statutes like the Clean Water Act by Congress, being revisited by Congress in light of the new composition of the Supreme Court and what's likely to be the composition of the Supreme Court for
quite some time?
Quite some time.
Yeah, it's hard to know. I think a lot of folks were surprised that Congress moved forward on the Inflation Reduction Act, which cobbled together a host of climate-related policies. It wasn't near the climate policy that we might have had back in 2009 if we had adopted an overarching cap and trade program for climate. But it was a significant achievement that a lot of folks didn't think you could get through divided Congress. So maybe there's some room there. I think the Sackett decision, you compare it to West Virginia v. EPA, and a lot of folks have made those connections. The Sackett decision is even more shocking to me because in West Virginia v. EPA, you're dealing with EPA trying to regulate greenhouse gas pollution in a way that they really had not done before. They tried in other ways that the courts had knocked down. And so it was admittedly a somewhat novel approach to regulating greenhouse gas pollution. Whereas here we're talking about, since 1977, at least a minimum amount of neighboring wetlands were common sense seen and protected as adjacent across every presidential administration. I remember environmental groups were very upset with the Trump rule on waters in the United States because it rolled back so many protections. But at least it recognizes, well, there are some wetlands that might be pretty close to a navigable waterway and are so obviously connected, we're going to still have to protect those. We don't even get that much. So I really see this as a bigger decision than West Virginia v. EPA in terms of its impact.
So thinking back to the connections with the West Virginia case, the Biden administration took a big hit on its proposed power plant regulations through the West Virginia case, but then they went back to their quarters, figured out what they were going to do to try and come up with power plant regs that would fare better at the Supreme Court, which they've now done, and issued their draft regulations as kind of the response to West Virginia. Do you have any insights on, who and how people may be scuttling to figure out how to work within this new framework on the water side after the Sackett decision?
Yeah, I guess the short answer is I don't know.
Yeah.
Who's moving on it. The whole thing feels a little bit like just sort of the way the clear statement rules that the Supreme Court is developing in recent years. And by that, folks, clear statement rules, people mean we're saying that Congress has to speak in very explicit, clear tones and words on what exactly they want an agency to do. And if they aren't sufficiently clear, the court's going to throw the whole regulation out. It's feeling a little bit like that old sort of, Charlie Brown and Lucy in the football, where the court keeps sort of developing a doctrine to strike down one rule, strike down another rule, and saying, "Oh no, you guys can try again, absolutely," and then pulling the football again away with the next rule. So, yeah, I think maybe back to your first question, we'll see more action at the state level because action at the federal level is proving so. It's difficult to find traction moving forward.
Yeah.
And it's frankly difficult to predict, right? I mean, the crazy thing to me about the Sackett case is, if you've got 45 years of undisputed agreement on at least a minimum amount of wetlands that are protected, and that gets tossed out, it's hard for the president and Congress and other actors to try to anticipate what the court's going to do. To me, it struck me as a very unpredictable decision, which means it's very hard to figure out how to go forward under it.
Yeah. Okay, we'll have this be our last question. The Sackett decision seems to deeply disregard, if not disdain, science, which is, of course, troubling. Are we in an era of an anti-science federal judiciary? And if so, what are your thoughts on how to navigate that?
Yeah, it is true that there's very little discussion. Again, there's no discussion on sort of the objectives that Congress wrote into the Clean Water Act about protecting the chemical, physical, and biological integrity of the nation's waters, which if they had talked about that language would have led them to saying, oh, there's a lot of, there's an amicus brief from wetland scientists that explains how Steph Ty at Wisconsin, they wrote one of the briefs on this in the Supreme Court that explains very clearly how these adjacent wetlands impact water quality. And so, yeah, there's no discussion of any of that in the case. But I think, to some extent, you might say, well, those are public policy questions that Congress and the agency should be evaluating as they draft laws and implement regulations. And what's shocking to me is not so much the lack of deference to science, but the lack of deference to these co-equal branches of government.
Right, which may be, at least in the case of the executive branch, where the experts on science reside.
Absolutely.
Okay, we are out of time, and I know some of our students and professors have to get to their afternoon classes. So thank you again, Professor Jaffe, for your great presentation. And thank you, everybody who joined us today. Our next talk will take place online in the same fashion on Tuesday of next week. Have a good rest of your week.
Thank you all.